Hi guys, it's Kathy. I hope you're doing better than me. I hope you're doing better than me and Fozzie. Pittsburgh lost today. Damn Ravens. Damn Ravens. It hurts. It hurts. It hurts. It hurts my heart. But that's football, I guess, right? So let's watch some court videos and try to suffer through it. So I know a lot of you got some snow. I hope all of you are able to get out. I see Donald can get out fine. He fixed his snowblower, so he's good. I have kids. I made them shovel. So they shoveled once, but it snowed twice. So now I'm going to have to shovel tomorrow. All right. We have one from Georgia, one from Jersey, and then we're going to Fleischer. Yeah, the snow pics. The snow pics are really good. I love them. They look so pretty. Bonjour. Charlotte's here. Everybody. Away from France. Oh, man. Now I want a baguette so bad. I'm not shoveling for you, Bobby. You shovel for me. Oh, wow. Weird Al. You mean the movie? Excellent. It was excellent. It was so good. Anyway, let's get to court videos. This one's just a short one.
Okay, last name Crow?
Yes.
Thank you.
There is not an E on it. I'm just Indian. Sorry.
Okay, we'll see you Thursday.
Thank you. Have a good day, sir.
Thank you.
We'll see you in a couple of days.
Yes, sir, you will.
And Judge, just going on, Kinley Desir was supposed to have a bond hearing at 2 o'clock today. His family's in the courtroom. He does have an attorney, and I don't suspect the attorney be appointed by that time. Should we tell the family just come back maybe when he gets an attorney?
Hold that thought 1 second.
Yes, Judge.
Mr. Velasco, you're on the arraignment calendar, case number 19. Are you going to represent yourself, hire an attorney, apply for a court-appointed attorney?
Did the arraignment?
Now, you've been indicted in case number 24 CR 1349 with the offense of possession of a Schedule 1 controlled substance, that being THC, and count 2 possession of marijuana less than an ounce. So that charge has been formally filed against you. And the question is, 1, do you want to plead guilty or not guilty? And 2, are you going to apply for an attorney, hire an attorney, or represent yourself?
Can I sit up here, Your Honor?
Sure. Okay.
I understand the seriousness of my charges, Your Honor, and I respectfully request a diversion plan to better me and to keep going down the right path, because this is my first felony and I haven't been adding my charges. I haven't been getting in trouble, and I work at Northside Hospital, and I just don't want that on my record.
All right. Well, you're getting a little ahead of yourself, okay? Because you need to, you got charges, you're going to have to plead guilty or not guilty.
Yeah, I'll plead NOLO.
Why don't you plead not guilty today and see if you can get an attorney to help you work it out so like you can.
So like a continuance.
All today is just plead not guilty. Okay?
All right. Yes, sir.
So if Mr. Saxhaven can get the file, we'll let you enter plead not guilty. And then
That's how every single one of us would sound like if we went to court, because we know just enough to say, I'd like a deferral. I plead NOLO. I guess this is a continuance. That's what we would sound like.
if you'll go down to the second floor, Have you applied for a court-appointed attorney yet? Okay, so go down to the second floor at the end of the hallway and apply for a court-appointed attorney.
Right.
Okay.
I think he has one. He brought one.
He has a black one right now.
That's fine.
All right, and I'm gonna withdraw the bench warrant on case number 19. All right, so you entered the plea of not guilty, that's good. Now, just go down to the second floor, all the way at the end of the hallway is indigent defense. Go down there and tell them you need to apply for a court-appointed attorney,
All right.
okay?
And then after that, they'll tell me
Then
the
you'll get a
process.
notice of when to come back to court, but hopefully you'll get an attorney and they'll be able to help you figure out what to do next. So,
All right. Thank you, Your Honor.
yes, sir.
Have
You
a
have a
good
good day.
You too.
Thank you. All right.
When you look at that criminal history, you might think, why hasn't there been a recovery court application? I can provide Your Honor with some insight to that.
That's not pertinent to what we're doing here today, Mr. Ure. You can move on.
I just got a text from my son, Texas. My son is at the airport leaving Texas right now. I hope it's not burning, but you know, you guys are big boys. You can handle Anthony. I don't know how you can handle Anthony. I can't handle Anthony, but he's leaving you now.
It's pertinent for the violation of probation, Joe. So he was
Well,
placed on violation.
it's actually a revocation of a suspended sentence, and we're going to deal with that later on in this matter. And I understand that there was an instant warrant that was issued by Judge Gibson on January 6th, which is 2 days before the initial listing of this matter. We'll deal with that in a few moments, Mr. Ure. Relative to
Thank you.
release for detention, I'll hear from you.
So this just goes to following orders, Judge, for detention purposes, if there was conditions placed on him.
Well, that's different than recovery court. So if you'd like to talk about that, that's fine.
So that, I'll move on from that bit, but he was
Thank
placed on suspended sentence. So he has conditions. And the only condition, the main purpose of that was to just remain law abiding. Now we are here. So if Your Honor were to release with conditions, I think there is a track record here,
I don't
unfortunately.
have court here today.
Judge
not-
Smith, can we mute the court? I guess we can't mute the court. Sorry, Judge Smith, you're just broadcasting, just so you know. Mr. Ure.
So we have that history of not being able to follow one condition only, remain law abiding.
I'm sorry, hold on one moment. The Court Smart is running in the courtroom, so everything is being picked up.
Thank you. Mr. Ure.
So in terms of detention, Judge, I
Thanks for that, Kelly. Thanks for that. Maiko, you have 4 kids. You know that it's harder to sleep with no noise in the house. Practically impossible to sleep when there's no noise in the house. And Fozzie, you have kids. I don't get details. I don't get words. I get grunts, you know. I'm in Texas. Where in Texas? What city you in? I don't know, down south somewhere. I don't know why. I have no idea. I know when I'm going to find out, though. Probably tomorrow morning, right before I'm about to stream, he's going to break into a long-winded explanation about everything. And I'm like, hurry up, hurry up, hurry up. Hopefully he's not going to get here until 2 p.m. So he's got a long way to go.
note that violation simply because it indicates that there's an issue following conditions. If the defendant were released, obviously a condition would be to remain law abiding. Here we have a victim, a very serious crime, NERA offense. For those reasons, I think he does pose a danger to that victim, to the community, and should be detained pending resolution of his case.
Thank you. Ms. Weigel.
Your Honor, I am going to ask that you follow the recommendations of the safety assessment and allow my client to be released with reporting conditions.
All right, she's about to say what he did. And I liked it.
The recommendation on the PSA is for bi-monthly reporting. My client scores a 3-3. He is not a flight risk, I would argue. He does have a history of residents at the motel in question where this offense occurred. He's been there for 1 year. He's been in Cape May County for far longer than that, Judge. And he does understand that if he is released, he may be required to find alternate residence so as to make sure that there's no contact with the complaining witness. Excuse me. My client does not have any failures to appear within the last 2 years. The most recent failure to appear is from 2018. That's quite some time, Judge. It shows a history, I would argue, of Mr. Rivera making himself available to the court when it is required. As far as my client's prior indictable convictions, Your Honor, there is no history of violence in this in my client's case. My client represents, and although it doesn't go directly to probable cause, there has been some history with the complaining witness in this case. My client represents that that gentleman has been harassing my client. I would agree with the state's reading of the video that as soon as the two came into contact, there was already some issue between the two. And I would argue that my client having the kitchen knife in his hands was not something that he went and got. This was something that he had in his hands coming from his neighbor's house back to his home.
Because every time I leave my neighbor's house, I carry a kitchen knife. And it's just a coincidence that while I'm carrying this kitchen knife, I run into a neighbor that I hate and that I have a past beef with.
And this was something of a situation where he felt the need to defend himself. My client does not currently have any medical no current medication that he is following. However, he does represent he's had a very significant back injury in the past. And that does affect his ability to work. He's disabled and receives SSI benefits. If my client is taken into custody, Judge, kept for, I believe it's over a certain amount of time, he will unfortunately be losing those benefits. He would have to reapply for those. Obviously, I've already explained to my client.
I was thinking buttered, and you went with paired. But speaking of buttered, I thought about this yesterday while I was working. And I wanted to ask you guys. All right, we all know some people, and I don't know how, but we all know some people that hate bacon. And we all know some people that hate chocolate. And we all know some people that hate peanut butter. And we don't understand how or why. But there are people on this earth that hate those things. But I have never heard of someone who hates butter. Something buttered. Does anybody here in chat hate butter? Like, oh, I just can't do butters.
Even if Your Honor does release him today, we will have to address the warrant that is issued by probation. But I would argue that even the information from probation shows this is his only offense. My client does have these new charges. The recommendation is for release. I would argue he is not a flight risk. Conditions can be put in place to make sure that he stays away from the complaining witness, up to and including being advised that he must find alternative lodging, which my client is willing to do. And I would argue that that would follow the recommendations of the PSA, make sure that the complaining witness is protected, and make sure that my client is a safety to the community does not have anything to fear from my client, who again has no previous violent convictions. Thank you, Judge.
Thank you. Mr. York?
Nothing further from the state, Judge.
Yeah, by the
Will you
stick.
please give the court 1 moment. This is State versus Carlos Rivera. We have complaint warrant 25-6-0506. The court incorporates the facts it found when it determined probable cause as if they're set forth at length. At the time of the instant offenses, defendant did not have any pending charges. Defendant has 1 disorderly person's convictions for shoplifting. The defendant has five indictable convictions for possession of CDS. Defendant does not have any failures to appear within the last 2 years. He has 3 failures to appear which are older than 2 years. Defendant is currently serving a 4-year suspended sentence for his most recent possession of CDS conviction. That suspended sentence was entered over 2 years ago on December 8th of 2022. The PSA has a score of 3 for failure to appear and 3 for new criminal activity. The PSA recommends release on level 2 monitoring. Defendant has been a longtime resident of Cape May County. The defense proffers that the victim has been
Drug charges, I think.
harassing the defendant. The parties have a negative history of interactions. Defendant is disabled and receives SSI benefits. The court attributes weight to the recommendation of the PSA. The court has considered the nature and quality of the charges. The court has considered that the defendant is currently on a suspended sentence. The court must balance these facts with the principles of criminal justice reform. Here, the defendant is 54 years old. He does not have any prior violent convictions. His history of failing to appear is remote. This may be a mutual fight. His criminal history suggests the defendant has a history of substance abuse challenges. The court has considered the likely outcome of these charges. The court has reviewed S3 today during the hearing. The interpretation is left to a trier of fact. More occurred in the incident than was narrated or presented by the state. As such, the state has failed to meet its burden. Based on these facts, the court finds it can impose conditions of release which would protect the safety of the community and assure that the defendant does not obstruct the criminal justice process. Based on the totality of circumstances, the state has not met its burden by clear and convincing evidence. Therefore, detention is denied and the defendant will be released. However, release on level 2 monitoring is insufficient. The defendant will be released on level 3 monitoring subject to conditions. Mr. Rivera, if you can hear me well, give me a thumbs up. Mr. Rivera can hear me. Thank you. I'm going to give you your conditions of release. You shall appear for all court proceedings. You shall immediately notify pretrial services of any change of address, telephone number, or other contact information. You shall not commit an offense during the period of release, which means you can't pick up any new charges. It doesn't mean you need to be convicted of them. You are prohibited from all contact with the victim. You are not going to reside at the Flamingo Motel or appear or present yourself at the Flamingo Motel. You are going to report to pretrial services telephonically once every other week and in person or by video once every other week. You shall refrain from possessing a firearm, destructive device, or other dangerous weapon. You shall refrain from the excessive use of alcohol or any unlawful use of a narcotic drug or other controlled substance without a prescription by a licensed medical practitioner. You are going to comply with all recommendations and requirements of pretrial services. You may retrieve your belongings from the Flamingo Hotel only with a police escort. Now, there are the conditions of your release. When you are released pretrial, you also have responsibilities and obligations. You must notify the court immediately in writing if you're detained in jail or prison or otherwise cannot appear at a court proceeding. You must provide pretrial services with a valid cellular phone number or email address to which you have access to receive reminders for your scheduled court appearances. If you fail to appear at a court proceeding and are arrested in another state or jurisdiction, you agree to waive all rights to
No, this is the interpreter right here.
extradition proceedings under New Jersey statutes and demanding states or jurisdiction statutes in regard to extradition law. Failure to appear, violation of any of the conditions I've given you, or commission of a new offense, remember, that's picking up new charges, not necessarily being convicted of them, shall result in one or more of the following penalties and consequences: issuance of a warrant for your arrest, increasingly restrictive conditions. You're basically at the top. So there really aren't any other conditions I could impose. Most likely, Mr. Ure or the state will file a motion to revoke your release. You may find yourself detained, which is where you are now, which is where I don't believe you want to be. The next court date on this matter is February 27th. You're going to get an order when you're released. We're going to talk about how that's going to work. It's going to have a phone number for pretrial services in the last paragraph. You need to call them within 24 hours of your release to set up your monitoring. You're currently serving a suspended sentence. I have not changed any of the requirements of that suspended sentence, and it continues. It's consistent with my order of release, which says you shall not commit any new offenses. Now, is the state intending to pursue the violation, what has been lodged as a violation of probation, which is a revocation of the suspended sentence, Mr. Ure?
It would be, Judge. Obviously, however this case resolves, it would be resulting in a violation of suspended sentence. So it would be.
Well, it may or it may not. For most of the counties, that would be placed on a control date pending resolution of this matter to see whether or not the defendant actually receives a conviction or if this matter is resolved otherwise. However, I understand the state's position. Ms. Weigel, you're going to be the public defender assigned to Mr. Rivera?
Yes, Judge.
All right. It's my understanding that there was a hearing that is scheduled, I believe it's later in the month, either on 1/27 or it may be the 2/27 date for that violation of probation, as it's filed. I've read the recommendation going from suspended sentence to state prison. I'll leave that for Judge Gibson. However, I'm going to schedule that, Trish. That should be placed on Judge Gibson's list for Tuesday, January 14th. I will let Judge Gibson's chambers know as well that I've scheduled it for that day. Anybody have any concerns about that, Mr. Ure?
No, Judge. I don't know what the order said. I don't know if it had a tracking date, but I'm sure they could change the schedule for that.
Ms. Weigel, any objection to that?
No, Judge, I would appreciate that date on the 14th. My client obviously is eager to address the detainer issue.
I have very grave concern given the fact that Mr.
He's eager to address these, Your Honor.
Rivera is receiving SSI, and that depending on the scheduling of this, it could significantly impact his status. And to give it a longer date based on what the court has seen in the video and the proffers of both counsel concerns me. But I'll let Judge Gibson deal with that on Tuesday. Trish, any difficulty with rescheduling that VOP for Tuesday? I understand that is Judge Gibson's probation day.
As far as I know, I don't handle Judge Gibson's list, but I will certainly reach out to Ms. Bellotti and make sure we're covered. It'll either be Monday or Tuesday.
Thank you. I very much appreciate that.
You're welcome.
Mr. Ure, anything further on this matter?
Nothing from the state, Judge.
Ms. Weigel, anything further?
Nothing from the defense. Thank you, Judge.
Okay. Mr. Rivera, you can go ahead with the officers. You will, Ms. Weigel will be representing you relative to the detainer that's been lodged, and she'll, I'm sure, be talking to you about that. Thank you. Ms. Martin, thank you for your help today. Judge Smith, I'm going to turn everything back over to you.
Okay, thank you, Judge Garabran. Have a nice weekend.
So Judge Smith did have one hearing today, and I wanted to get it. It started out great, but then it was just boring. So I didn't. I got it, but I'm not showing it because this is too boring. We're gonna go to Fleischer. That is absolutely not Fleischer. That is just 100,000% not Fleischer, even though it says right there that it is Fleischer. So if you guys will just watch this, even though you've probably seen it before, for a moment, I'm going to go get Judge Fleischer. One moment.
The objection is overruled.
So you mentioned that Barb asked if you were okay. Did you have a quick conversation with Barb?
Yes,
Did police eventually arrive?
yes.
How were you feeling once Barb was there, the defendant left?
I felt a little bit better because I knew like I was safe once I saw Barb. So once she came to me, asked what was going on, she asked if I called the police. I told her yes.
So I'm gonna stop you right there, because we already talked about that you guys had a conversation. Police eventually arrived.
Yes.
How long did it take for police to arrive, do you know?
I'd say about 4 to 5 minutes.
Did you talk to police?
Yes,
Did police take pictures?
yes.
May I approach this witness, Your Honor?
You may.
All right, Jada, I am going to hand you some pictures and they are going to first be, we're gonna go through states. Excuse me. Okay, 3 through 9 inclusive. Could you just take a moment and look through those? All right, 3 through 10 inclusive, I apologize. So Jada, are those pictures of your apartment?
Yes,
Pictures of the outside of your apartment that day?
yes,
Pictures of the inside of your apartment that day?
yes,
And do those fairly and accurately depict your apartment back on June 14th of this year?
yes.
Okay, so I'm next going to hand you states exhibits 11 through 16 inclusive. Those are marked for identification purposes. Could you take a moment to look through those? Jada, are those pictures of you?
Yes,
And do those pictures fairly and accurately depict what you looked like back on June 14th of this year?
yes.
Your Honor, the state moves to admit proposed exhibits 3 through 16 inclusive.
I don't know, did I hear anything about 10?
I did. I corrected myself.
Okay, I apologize. I missed that correction. Mr. Altenhoff?
Are you okay? First live from the emergency room.
The court will show that states exhibits 3 through 16 inclusive are admitted without objection.
Permission to publish electronically.
You may.
Thank you.
Ouch. Oh no, that's yucky.
So Jada, we're going to go through these pictures one by one, and they're going to be up on a screen behind
No, Your Honor.
I'll formally accept the terms of the plea and revoke the probation in the F6216 cause and impose a sentence of 270 days in the Marshall County Jail, all of which will be served, subject to good time credit and credit for time served, and formally enter the judgment of conviction for the possession of methamphetamine charge as a level 6 felony in the F6143 cause. And the sentence on that level 6 felony will be 180 days in Marshall County Jail, all of which will be served, subject to good time credit and credit for time served, noting that all time will be applied towards that sentence first in the F6143 cause, and then transitioning over to the violation of probation. As it relates to the dollar fine plus court
You got any left over? Asking for a friend.
cost and the $200 countermeasure fee, Mr. Morris, you are hired on that case.
No, it's downloading. So we're just this is 5 minutes long. I don't know what it is, but it's 5 minutes. We'll watch while Judge Fleischer is getting ready.
Correct?
Yes, partially hired.
Partially. So you might have limited ability to pay both your fees as well as those fines and costs.
I do believe that she has the capability of making money when she's out, but she's certainly not rolling it down. No.
Well, Ms. Smith, if I give you some time to pay those fines and costs, do you think that you will be able to come up with that money?
Yeah.
You think 6 months is sufficient time?
Yeah.
I'll impose the dollar fine plus court costs, and I'm of the opinion to impose it as a civil judgment today, and then she'll have the adequate time to pay that. So, Ms. Smith, what I'll do is impose that as a civil judgment, and then you'll have some time to pay once you're released. If you have someone that can pay it on your behalf, they can also come to the clerk's office and pay it while you're incarcerated. But once you're released, come to the clerk's office and give them that 07 F6143 cause, and then you can pay off those fines and cost obligation. Until you do so, it'll stand as an order and a judgment in favor of the state of Indiana and against your name. Count 2 will formally show dismissed in that cause, and as was mentioned and agreed upon in the plea, both of these sentences will be imposed consecutively. Ms. Smith, any questions over the terms of the sentence or what occurred this morning?
No.
Further?
Nothing further.
Mr. Stanko?
Why, thank
further,
you,
Your Honor.
Mrs. Brown. I appreciate it.
Ms.
Thank
Smith,
you.
best of luck to you on finishing serving the sentence and then being reintegrated once you're released. Thank you, ma'am.
You're welcome.
All right, Matthew, that was pretty boring. Thanks a lot. I counted on you. There we go. There he is.
Page 11. Good morning, Mr. Martinez. Good morning. Mr. Martinez, you're charged with racing on a highway. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 27, 2024, the officer was assigned to a traffic crimes task force and followed a group of 40 to 50 racers from 2400 block of Turning Basin to the 610 loop. The officer
So 40 to 50 racers?
Yes, Judge. And the officer observed the defendant and co-defendant's motor vehicles in lane 1 and 2 slow down to approximately 30 miles per hour, and both vehicles took off side by side, trying to outpace each other at approximately 100 miles per hour. A traffic stop was conducted, and the officer made contact with the driver and the defendant, and he was the sole occupant of the vehicle.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has a valid?
He's not eligible, Your Honor.
You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive, and I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing every time you drive. It's an offense in and of itself, punishable by up to 6 months of jail and a $500 fine. Do you understand? Do not drive.
Whenever you fill out the affidavit promising us you're not going to drive, we will get you to Victoria, sign a reset, and we're going to get you out of here. When you come back, please have a lawyer. Yeah, can you file no racing, reckless driving, and all that, please? Yes, Vic.
Okay. Here is page 10. McLean.
Judge Fleischer's taking a break from YouTube right now.
Todd McLean.
All right, Judge. Next is page 13. Bottom of 13.
Turubiartes, come up.
Caden Brunston. Come up here to clerk. Caden Brunston.
So you are charged, do you speak English?
Yeah.
Yeah, no. John, better. You're charged with reckless driving, up to 30 days in jail and or a $500 fine. Hey, Conrad, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
I apologize, Your Honor. What's the last name of this?
Turubiartes, Turru.
Thank you, Your Honor. The officers were surveying a known street takeover group in a large parking lot in Harris County, Texas, when the officers observed the defendant's vehicle spin its rear tires and do approximately 4 to 5 donuts in the pit, coming within 10 to 15 feet of other vehicles. Undercover officers kept their eyes on the vehicle until other officers were able to conduct a traffic stop.
It's like you're speaking directly to my heart, Allie. Thank you.
Undercover officers also identified the driver as a slim Hispanic male with curly hair. The officers observed the defendant in the driver's seat and the defendant admitting to doing donuts.
Right. Sir, I'm going to find that there's probable cause to go forward with the case. Have you seen if he has a valid license?
I'll run it, Your Honor.
Please. I'm ordering you as a condition of your bond not to partake in this type of behavior again. No racing, reckless driving, donuts, street takeovers. If I find that you do, I'm going to put you in jail. No more PR bombs. Do you understand, sir?
Yes, Your Honor.
We are all happy Snoopy's not here when he says words like no donuts.
I apologize. It's loading right now.
Yes, no problem.
I get that. I understand, sir. Don't worry. Take your time. Fozzie's going to yell at you, too.
Okay. You mind crafting those orders? We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. We'll get you in the jury box. We'll get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Be careful. Don't drive like this again. Do you understand?
Yes, Your Honor.
All right, Judge. Next is page 14. Wallace. Come on up.
Brianna Bryant.
Good morning, Miss Wallace. You speak English?
Yes, I do.
Okay, ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 27, 2024, the officer was dispatched to a disturbance at an apartment in Harris County, Texas. The officer made contact with the complainant, and the complainant and the defendant are cousins. The complainant and the defendant do not live with each other, and the defendant was staying with the complainant for a couple of days. The complainant stated she and the defendant got into an argument about the defendant's lifestyle. The defendant became upset and started to throw the complainant's belongings out of the apartment. The complainant and the defendant continued to argue, and the complainant tried to open the door to retrieve the belongings, and the defendant grabbed the complainant's arm, applying pressure and scratching the complainant's arm, causing a deep cut, bruising, bleeding, and pain. The defendant stated she had been arguing with the complainant earlier in the day, and the defendant stated she got fed up with the complainant criticizing her and asked the complainant to leave. The defendant stated the complainant pushed her and took her phone, and the complainant's small dog caused an injury, and the defendant did not recall injuring the complainant.
Do you know if alcohol played a part in any of this?
There's no allegations, Your Honor.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand? These are your bond conditions. If you violate these conditions, a warrant will be issued. You will go to jail. No more PR bonds for you, man. We will do that. We'll give you time. Yes, we're going to do that now. I'm going to have you sign a receipt. Victoria will give you 30 days, but I'm going to have you also take a seat in the jury box. So we'll get your bond conditions. We'll have you sign it, and then you'll be free to go then. All right? Please. Same thing, no contact, no weapons.
All right, Judge, next is page 14. Where? Come on up.
Gary Allen? Gary Allen.
I'm singing. I'm getting donuts. I'm getting donuts.
Oh, he's outside talking to his lawyer. Okay. Just kidding, saying. You are Brett Ware? Mr. Ware, you're charged with unlawful carrying of a weapon. You're facing up to a year of jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 28th, 2024, the officer was dispatched to a robbery that just occurred in Harris County, Texas at a restaurant. While en route, the officer observed males walking on the south side of the store where the robbery had occurred, matching the description the reportee provided. The officer called in an attempt to contact the two individuals and located the two males wearing dark hoodies, dark pants, and shirts tied to their heads that looked like makeshift ski masks. The officer made contact and asked if it was okay if they were patted down for weapons, and both individuals ran off. A short pursuit lasted approximately 50 feet, where the co-defendant slipped on a puddle of water, and the defendant ran approximately 5 feet before being grabbed by the officer. The defendant, 19 years old, whilst trying to stand the defendant on his feet to walk into the patrol vehicle, the officer found on the defendant a loaded Glock 9mm, which fell out of the pant leg of the defendant.
So this is part of an ag rob as well, right?
Amanda Martin.
Yes, Judge.
What happened on the ag rob?
One moment, Your Honor. So during the ag rob, the complainant stated that while he was walking into the store to grab his food order, the two males stood outside the store watching him, and as he walked out of the restaurant, they blocked his path, and one of them pulled out a gun on him, and the other yelled at him for his wallet and keys.
Where is this?
These aren't even my pants.
It was, one moment, there's an address, but not a name of the business. At a Sonny's food store.
Got it. Mr. Ware, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. No more PR bonds. I'm now also giving you a curfew. I don't want you out in the middle of the night. And I'm going to put a monitor on your ankles so I know where you are at all times. Do you understand? If I find that you're a danger to my community,
He's not a real judge. He's just playing one for the cameras.
I'm going to lock you up and I'm going to make your bond so high. Do you understand, sir? No contact with the co-defendant in this case and no weapons as well.
Yes, sir.
How old are you, sir?
19.
Did you graduate from high school?
Yes, sir.
What are you doing with yourself now?
Not much.
Are you working?
No, sir. I was planning on going to the military. I was talking to a military.
I want to know what you're doing with yourself. If you're working, if you're doing anything, because I want you to get a job. Too much time on your hands, you become self-destructive. You need something to do.
What's the license? I know we're going to a class before Clifton.
Good. Get it done. You need to get a job, and I want to make sure that you're going to get a job. I'm going to provide you a lawyer today, but I want to see here within the next couple of weeks what you have done to get a job. If you've done nothing, life's not going to go well. Do you understand? In this life, you have to be productive. You have to either get yourself an education or get yourself a trade, a job, because I'm going to tell you now, when you turn 40, if you don't have a career, if you don't have an education, if you don't have anything, this life is not going to be a good one for you, because I'm going to tell you, life sucks without money. You need money. Otherwise, it's going to be just a rotten toilet of an existence. Do you understand? So we're going to make sure here you're going to leave better than you came. So you must either get a job or get into school full time. Do you understand?
Yes, sir.
I'm going to give you a lawyer today, and I'm going to bring you back in 2 weeks, and we'll see what you've done with yourself.
Yes, sir.
All right.
This way. You want to sign the release?
No. I got one on the ag
Judge,
round.
do you have anybody in the waiting room?
Jerry Harvey?
No. Elon, you ready? You've been waiting for a while. Let's get you done.
Judge, we have one more.
Come on.
Page 10, McLean.
Todd McLean. Mr. McLean, you're charged with interference to the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The officer was dispatched to an apartment in Harris County, Texas, in response to a disturbance. Prior to their arrival, the officers were told the defendant was in an altercation with the child's mother.
I don't like you under the stairs, Donald. You have to stay out here. Thank you, though. Thank you.
Intoxicated and had a firearm. Upon arrival, the officers observed the defendant banging on the door to his residence, and the officer told the defendant to show his hands, and the defendant ignored them. The defendant then pulled his handgun from his waist to show the officers that he had it, and then placed it back into his waistband approximately 4 times. The defendant eventually put the handgun down, but told officers they would have to tase him to get him to stop. The officers then attempted to detain the defendant, but the defendant continuously pulled his hands away and kept placing them in his pockets. The defendant was then tased twice, but kept putting his hands back into his pockets. The officers were eventually able to detain the defendant.
Did you say, initially you said he was intoxicated, right? Is that what you
Yes,
said?
he was reported intoxicated.
Okay. Mr. McLean, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs and not to be in possession of weapons. Do you understand? What do you do for a living, sir?
Photographer. Do photography.
Okay. What kind of income do you have from photography?
They come coming in, what you want to know, monthly?
Yeah. And do you have the ability to hire a lawyer?
Yes.
Okay. We'll give you time. So I'm going to have you meet with Victoria. We'll have you sign a reset. I'll have you get with Felicia for your bond conditions. After that, you're free to go. All right? Please. Okay. Ready? Yeah. Sorry to keep you waiting.
How are you?
Do we have Zuberi, right?
How are you?
Good, man. We have
We've been working hard. The case was filed late April. He had a retained lawyer in the beginning. He came to me middle of June. I subbed in late June. I had a couple settings.
Where do you want to go? What do you want?
We're asking for about 30 days to flush some stuff out. And I think ultimately, what I'm slightly disappointed with is the way the case was presented by the agency to the DA's office. It's not their fault. We've been put in a time crunch where we got to November and we began to run up against your 180 days. And I think we all kind of realized the agency didn't bring over what they needed to bring over.
Are you still lacking stuff?
I think we're all in a position where it's less, some of the initial discovery is complete, but because we're all working so hard, there's some subsequent discovery that needs to be done based on some things that have been said. And so Kelsey's been great. She's working hard, talking to people.
But I mean, what do I need to do? Because we're now at 240 days. We're still missing stuff. It's unacceptable.
I would suggest, this is one of those moments where I would say, we've all been doing this a long time. If you just trust me, I think we really just need 30 days to work on some things and then come back, and I think we'll be in a better position then to know with clarity.
I can't deal with this lawyer at all. No, I can't. I would never be able to like go out for drinks with this man. Nope, never.
Whether we're working this out or not, and we need a trial date.
Well, then, I'll give it to you, Lon, but at the next setting, it's player trial, you know? Like, that's it.
And I appreciate your position is like, hey, look, I've got and I have an idea of when and how I want to move things. Every now and then things get messy. This one's gotten a little messy, but
typically when we face this type.
Judge, I know what's going on. You need to trust me. I know how everything's going to play out. You don't have to ask me any questions. You just need to listen to what I say to you, Judge. I know way more than everybody thinks I do.
Of dilemma. What I do is I order them and I subpoena the people who have.
Yeah, this is a little different. This is different. And if we were in one, and I think you did that back in November because there were some screenshots or something that maybe weren't complete yet. And then so you asked for a compliance hearing, and then some more information was provided, which again really only happened because the agency in the beginning didn't have a detective assigned to the case to really work it up and dig it over. Like, I'm used to a small town, like detective work. This didn't happen here. And so a lot of it's been thrust in their lap, unfairly probably. And so she's good. We're all good. Got good
Right, so-
lawyers working on it. If you give us 30 days.
I'll give you the 30 days, but at the next setting, it's player trial. I mean, it's because by then we'll be, you know, what, 275? So we're close to.
Track 60 that I wasn't on it.
Yeah, I mean, and that's why I'm giving you the benefit of the doubt.
3 for 1.
Okay, all right, we got it.
Thank you, sir.
Okay, sure.
I'll get a date. Judge, thank you.
All right, thanks, Elon.
The one that had the two just cases.
Ma'am?
Yes, I do.
Okay. I have a translator here for you. You were charged with driving while intoxicated, first offense.
第一个指控是您被指控醉驾，
It's elevated to a Class A misdemeanor because of the high blow.
因为你吹气的时候，它的这个指数比较高，所以它的这个罪行有就指控加重，成为了第一级的轻罪。
You are facing up to a year in jail and or a $4,000 fine.
您将会面临高达1年的服刑，或者或者是$4000的罚金。
We are going to do probable cause. You have the right to remain silent.
你有权利保持沉默，我们将会做一个可能性的证据。
Anything you say can or will be used against you.
你所说的话可以，也可能将会对你不利。
Officers were dispatched to a major crash in Harris County, Texas.
在德州 Harris 县，警官被派遣到一个汽车事故现场。
Complainant told officers that he was sitting at a red light and was rear-ended by defendant.
指控者告诉警官，他当时在红绿灯那边等红灯，最后被一辆后面的车追尾。
Upon arrival, officers found the defendant standing next to his car.
在到达现场的时候，警官发现被告人在他的车旁边站着。
Defendant repeated to them that the accident was his fault.
被告人一直不断的告诉警官，这次的事故是他的错。
Officers observed bloodshot eyes, slurred speech, strong odor of alcoholic beverage, and poor balance.
警官当时看到他的眼睛通红，说话的时候不清楚，同时 它平衡非常有限，有一些酒精的影响。
The defendant admitted to drinking 2 beers.
被告人承认他喝了2瓶啤酒。
Standard field sobriety tests were conducted.
标准的现场酒精测试执行。
6 out of 6 HGN.
The interpreter requests a repetition.
6 out of 6 HGN.
HGN 的指数是6。
8 out of 8 walk and turn.
走路和转弯的平衡度是8。
3 out of 4 one leg stand.
一只脚站立的指数是4个里面有3个。
DIC red and breath consented.
DIC 是红色，然后它的这个呼吸也是经过同意的。
The results were 0.174, 0.174.
呼吸的结果是0.174， 0.174。
He has no prior DWIs and no license. I'm sorry, driver's license is eligible.
之前没有任何醉驾的前科，所以他的驾照是有资格的。
Mr. Luo, I'm going to find that enough probable cause exists to go forward with your case.
罗先生，我觉得我们现在有足够的证据，可以认为我们可以认定您是有罪的。
I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs.
But, Your Honor, the interpreter needs to clarify one thing. Go forward means that you can find them guilty or not.
I'm finding there's enough probable cause to go forward.
Oh, go forward. Okay.
Correct.
OK， 那抱歉，刚才说的是我们有足够的证据可以继续审理这个案件，而不是说你有没有罪，是继续审理这个案件。
I am putting conditions on his bond, and if he violates them, his bond will be revoked.
那我们现在给你一个保释金，那我们将会有相关的保释金的条件。如果要是您违反了保释金的条件，那您将会有后果。
I am ordering you not to consume alcohol or illegal drugs.
我命令您不要喝酒精或者是吸毒。
You will be randomly tested.
您会在不定时的情况下被检测。
If you fail to go test or if you consume alcohol, your bond will be revoked.
如果您要是在检测的时候没有过关，或者是您喝了酒，那您这次的保释金将会被撤销，将会被没收。 So the interpreter requests a clarification because there is some I couldn't hear some of the words. So if it's failed to the test and the consumption of alcohol, his bond is ineligible?
So what happens is if he tests positive for alcohol or illegal drugs, I will revoke this bond and put him in jail.
Okay, that's what interpreter was. Okay, 所以如果要是您的酒精测试是阳性的，或者是您喝了酒的话，那我们就会把您直接就进监狱，然后呢，您同时也没有保释金了。
We are going to reset your case to give you time to hire a lawyer.
我将会给你时间去寻找律师，同时我们也将会让您的出庭日期重新安排。
Do you have any questions?
有什么问题吗？
因为我有三高，我从来不喝酒的，只是因为那天过节日，过圣诞节我喝了以后，都是已经5、6个小时以后才开的车，但是我不知道为什么这个车是这么高。我从来因为我有三高，每天需要吃药，根本就不喝酒的人。
Okay, so I have high blood pressure, diabetes, and high cholesterol, so I hardly ever drink. And that was during the Christmas holiday season. I drank very little.
Ma'am, I don't talk about the case.
No, that's the interpreter's job is to interpret for, so it's not the
Right.
interpreter interpreting, it was Mr. Law was talking.
I don't want you to say it because he has the right to remain silent.
Okay,
Anything he says, they can use it against him. And I don't
Okay.
want him to say something that hurts the case. I'm trying to
Okay.
prevent that from happening.
Your
If
Honor,
you can tell
if you can address to the defendant instead of to the interpreter, I think
Okay.
that would be probably. 'Cause-
You have
Oh,
the
hell
right
no.
to remain silent.
Okay. 你有权利保持沉默。
I do not want to talk about the case now.
我现在不想谈这个案件。
Anything you say, they can use it against you to prove guilt.
如果你说的任何事情都可以作为您的这个证据。
The only thing you need now is you need a lawyer.
你现在需要的就是需要个律师。
We will give you time to go look for a lawyer.
我给你时间去找律师的。
Understand you're not to consume alcohol or illegal drugs.
你现在要理解的是，你现在不能够喝酒，也不能够吸毒。
Do not violate the law. Do not pick up any new criminal cases.
不要犯法，也不要去做任何违法的事情。
If you do, then I'm going to put you in jail. No more PR bonds.
But Judge, I'm just the interpreter. No, no, no. Bad girl.
但是你出现这样的问题的话，那你直接就进监狱，没有什么任何可以保释的机会了。
For now, I will have you sign a reset with Victoria.
那现在呢，你可以跟 Victoria 那边签一个重新安排出庭时间的文件。
You will then sign with your bond conditions, understanding the bond. You will sign a paper indicating you understand your bond conditions.
你将会签个文件，上面会表示你已经了解了保释金的条件，
And then you're free to go.
然后你就可以走人了，
Please.
对吧？
I need the interpreter for the bond conditions. So I'm not sure how to go about that.
Do you mind chatting me your cell phone perhaps, and then I can give it to our pretrial services officer and she can go into one of the witness room and call you? I can, so that you guys can go over the bond conditions together. Is that something you can do?
Sure, as long as your honor permits. And your honor, you're talking to the interpreter, right?
Yes, yes.
Anthony, thank you so much. Thank you. And while I have you, Anthony, listen to me for just a second. No, I wasn't in the service. I know you want to hear from service members. I wasn't in the service, but I understand a 10-year-old grudge. And I'm telling you, all you're doing right now with the way you're thinking is hurting yourself. And the only thing that goes on from what you're doing right now is you're just going to hurt yourself further and further and further. And you know what's going to happen to that man 20 years older than you? And nothing. Absolutely nothing. Even if you do what you want to do, nothing happens. Except you hurt yourself. You have to let it go. I know you can't. I know you're not going to. But you have to. Because all you're doing is hurting yourself. And why? Why are you hurting yourself? You're not going to get anything. You're not going to reach a goal. You're not going to make anything better. But you can make it better if you let it go and move on to something else. You said you've never played around the golf. Fine. Focus more on that than what you're thinking about, because it's not helping anybody. It's not going to help you. You're not going to win anything. You're only going to lose. Thanks to the memberships.
Okay.
Yes.
Okay. Yeah. Yes. As for your honor permits, that would be fine.
So if you don't mind just chatting me your cell phone, and I will give it to Felicia, my pretrial services coordinator, and then I can have her reach out to you. You guys can do it via speakerphone.
All right. my gosh, you got my son, Anthony. You got my son. You gave my son, Anthony, a gift membership. Thank you. I wasn't going to pay for him.
If that's okay.
That will work. All right.
That's a Friday. How far? Maybe 21st.
And Deputy, do you mind accompanying her in the witness room with the defendant, please? Okay, if you want to go ahead and log off, I can have her reach out to you now.
And just one more thing, Your Honor, I just want to attorney know that the interpreter cannot be in the room with the defendant without anybody else present. So.
I'm gonna have an officer in there as well.
Okay, sounds good. Thank you. All right. Your Honor, could the interpreter leave right now?
Yes, ma'am. Thank you so much for helping.
Thank you so much, Your Honor.
Yes, ma'am. Take care.
You too.
Hi, Josh. Ready?
Christopher Perez on document.
Okay, I think they've all been signed, Trey. No. Sign. Okay, they've all been signed. Okay, I'm sorry, Josh.
Yes, Judge, we were just, I wanted to address the bond amount. So his bond is set at 2,500 right now.
Who?
Christopher Perez on document.
Is he in custody?
In custody.
Page 20, Your Honor.
Thank you, sir. Christopher Perez.
Luis Martinez.
His bond is, so he has a open PCS that's at 10,000 and 10,000. And then I guess while on bond for that picks up an assault and it's at 2,501 because we gave him a GOB in September. We issued the warrant and because he failed to appear and now we got him. What would you like?
And I was mistaken on the timing. I didn't realize that was before. Okay.
So he was on bond for the felony, picks up this assault. We give him a general order bond, fails to come. We issue a warrant. Now we got him.
So yeah, he was asking for a PR bond.
Yeah, we gave him one already. And I mean, if he makes bond on the felony, come back, we can talk. If, you know, if a week or two, I'm amenable to it, you know. So just if you want to, the felony is set for 17th. If you want to do the day after, let's find out what happens there. Come back and we can talk. Yeah, for sure.
Sandra Gutierrez.
Michael. Yeah, come on up.
Raquel Biagas, Your Honor.
Did you look at PC?
I think, we're prepared for argument.
Okay. Morgan, are you ready?
Yes, Judge.
This
This
is-
is Biagas, correct?
Biagas, yeah. Go for it. Okay. Ball's in your court.
Your Honor, Mr. Biagas, when he climbed to the mailbox pole, he didn't stop. He got out of the car. There's no one to talk to. And so from there, he went to his residence, Your Honor. But, you know, it's not a case where he didn't identify himself or anything. And then we don't know what the restitution amount's going to be from the mailbox.
My concern was that according to the statute, right, it says that you're supposed to, I don't even know.
Take reasonable steps to locate and notify the owner or person in charge of the property of the collision.
What time, was this the middle of the night?
$1:50 in the morning.
I don't think it'd be reasonable to knock on anyone's door. I don't think anyone would open it.
I mean, reasonable steps, you know where the person lives, you hit their mailbox. It would be pretty easy to walk up and knock on the door.
Is that reasonable? I mean, if you go up to someone's door at 2 a.m. and you start knocking on the door, are you going to scare the?
Probably, Judge, but I would want to know if it were my mailbox and somebody ran their car into it.
Would you open the door and go out?
I would look through the peephole and I'd see,
I
and then I would
guess
see a
there are
black car.
other measures I guess you could take theoretically.
Do something,
Right, I guess leave.
Right.
Maybe leave a note on the door.
Okay, all right. Mr. Biagas, come up. I mean, reasonable measures, right? And I guess that would. Have you run his license, see if he has a valid Texas driver license?
It's an out-of-state Florida license that appears valid in our system.
Okay, Mr. Biagas, I'm going to find that there's probable cause to go forward with your case. I'm ordering you not to drive any vehicle unless you have car insurance in your name. Do you understand? If I find that you're driving without a license and or liability insurance in your name, it's not going to go well for you. Do you understand? Okay, you've got a lawyer. Listen to your lawyer. He'll take care of you. I will waive your appearance so you don't have to waste your time coming to court, but you have to stay in touch with Mr. Pham and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you or you pick up a new case, I'm going to revoke your bond, put you in jail. No more PR bonds. You understand? Okay, guys. Any conditions you think?
I'm okay with your conditions, Judge, just no driving without
Yeah,
insurance.
just
Law
be
violation.
careful out there, okay?
Do you guys have insurance? Can you rip the CW?
Yes.
And then we can settle it?
You did have insurance, hopefully. Okay, wonderful, great. Okay, all right, man. Take care, have fun. Can you file that? You mind those conditions? All right. Michael, he still needs to sign the conditions and then he can go.
Yes, ma'am.
Okay, so just.
Yes, sir.
Thank you. Okay, what was the last name again?
Simmons-Urban.
Page 11 and 12.
You picked up a new case, Miss Simmons.
Simmons
Urban, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You now stand charged with the offense of criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine.
Yes, Judge. The officer was dispatched to a club in Harris County, Texas in
Her lawyer deserves a medal or something bigger for dealing with this.
response to a disturbance. The complainant, an employee of the club, told officers that she had asked the defendant to leave and the defendant refused. The defendant had been trespassed by another officer the day prior, and the complainant stated the defendant continues to return to the location. During the incident, when the complainant told the defendant to leave, the defendant stated, "Leave me alone or I will hit you in the head." The defendant told officers that everyone at the location was trespassing and that she should have been given a pink paper in order to be trespassed.
Okay, ma'am, I'm going to find that there's probable cause to go forward with the case. You've picked up a new case. The only thing I asked you to do was not pick up a new case, and now you've done it. So what happens now? Corey?
Judge, I'm going to ask for you to allow her to remain on bond. The state hasn't filed, if that's what you're getting at. The state hasn't, the state hasn't filed a motion to revoke bond. I'm not prepared for it. If they have, ask for time for a hearing to be set. So we can, have a hearing based on evidence. She hasn't violated the bond conditions, from the previous case as far as they relate to going to the housing
She has,
authority.
though. One of the conditions is behave yourself, give no facts or rise to probable cause so that you violate any new laws. She's now picked up a new case.
Right. What I'm saying is related to your very specific orders about her not to go back to the address where her apartment was or the Houston Housing Authority address. She's complied with those terms.
But if I let her go now, that's enabling this behavior and telling her it's okay.
Well, Judge, I think it would be punitive if you put her in jail as opposed, well, that's not the purpose of bond, right? It's community safety and the community.
She's threatening people allegedly there to beat them in the head. She won't leave.
That's hearsay. Let me just talk.
Take her into custody, man.
Judge, that's hearsay. I think we're entitled to a hearing.
Yes, I'll give you a hearing. Sure. Whatever you want.
My arm is broke.
I don't know how else to, she's going to do whatever she wants to do. How am I supposed to handle it?
I'm not a threat to the community, so I'm not understanding, and as I said, that is hearsay. Is there any way, can you subpoena the cameras? Because I didn't threaten anybody, and there is also multiple witnesses that was there as well.
Chop, chop, Judge. Go subpoena the cameras.
Sure. So that's my job. That's not the judge's job, and I'll do that just like I've done for
Handle it.
the previous case. So, Judge, can we allow her to remain on bond until we have an actual hearing following the rules?
I haven't been around the,
Following the rules of evidence for bond revocations.
Here's what we'll do, Corey. What I'm going to do is I'm sending you for a drug and alcohol test now. If you fail to take the test, if you fail to do what you're supposed to do, I am going to revoke your bond and put you in jail. I'm now putting a GPS monitor on you and I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
hey, 1 second. I'm homeless because they had refused to let me back into my apartment.
I'm not going to talk to you. This is not a negotiation.
No, I'm
It's
not.
Either you follow the conditions of bond or I'm going to revoke it and put you in jail.
Okay.
This is better
So
than being in
whatever
jail,
you want.
unless you want to be in jail.
Your lawyer's asking me not to put you in jail now.
Well, how long
You
will I be in
pick
jail?
Case.
Until November the 22nd?
No, I'm sending you for a drug and alcohol test now. We are going to reset this case until Monday. You were to come back Monday so we can address it. In the
I
interim,
did consume alcohol, not anytime soon, so that's fine.
I want you to listen. I'm going to put a GPS monitor on you and I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
Where is my curfew supposed to be from is the question. Because if I'm currently homeless and I am sleeping on the city streets, residing, because they refuse to let me back into my apartment, where
Know what you're doing.
is that supposed to be at?
That's what these conditions I'm giving you, ma'am.
It'll be within an exclusion zone. We do GPS within exclusion zones. So
Sure.
Have a permanent address in.
But I don't. I'm ordering you not to consume alcohol or illegal drugs. And I'm going to randomly test you, but I'm saying you now for a test, you're to come back Monday. Do you understand?
That's fine.
Okay. I'm giving you a monitor on your ankle. I don't want you going to any clubs, bars, or anything of this nature. Do you understand?
That's fine.
Thank you, Judge.
See you Monday.
Yes, sir.
And I'm sending her now for a test. I want to know what, if anything,
Where do I go to take this test?
she'll tell you.
Curfew's 9 p.m. to 6 a.m.? Okay, so if she's homeless, we need a home base for the GPS to observe the.
That's what I was trying to say.
She's got to live in somewhere. Got to be living.
I don't have friends or family or nothing, so that's what I'm saying.
You put your head somewhere down at night.
Yeah, on the city streets.
We'll get an address for it. Thank you, Judge. It's better than jail.
Yeah, it's not gonna be Xavier's either.
Maybe excuse me.
Craig.
Good morning again.
Hey.
I wanted to reapproach regarding the PC on Mr. Allen's case. I know the state has emailed me some cases that they wanted to cite to.
Morgan.
Judge.
I don't know whether someone else wanted to speak to that.
Yeah. If we may, upon reviewing case law, so as we've discussed before, so he did veer into the shoulder and then go back onto the lane. And in Hardin, failing to maintain a single lane with the added vehicle component is the danger that they provided in the case law that makes failing to maintain a single lane, unlawful. Furthermore, in cases such as Lamming and Martinez, the court added additional factors to consider for the officer into determining whether or not failing to maintain a single lane is unlawful. And one of those is the time component. In Martinez, it was at midnight or at 1 o'clock in the morning. Here it was midnight as well.
No, but one of the things is there's an element of unsafetyness, right?
And Your Honor, there are other vehicles around. As the officer articulated in the DIMS, there are other vehicles around when he veered and then jerked back into the lane, as the officer put in the DIMS.
But I get it.
And then,
but where are the other vehicles? Are they next to him? Are they in front? Are they in back? He doesn't articulate it. All he says is there are other vehicles.
And furthermore, Your Honor, what he did articulate into the shoulder, and upon looking at the statute for that, the Court of Appeals in Lothrop v. State articulated that there are 7 permissible reasons to go onto the shoulder, and there is reasonable suspicion to perform a traffic stop where there is not one of those permissible reasons. And here, the officer did not, with those other vehicles saying he passed the green light and then go halfway into the shoulder and then jerk back, it implies that there is not one of those 7 reasons to allow another car to pass, to stop or park. or to accelerate before entering the main lane of traffic, or decelerate before making a right turn. None of those are present. None of the 7 reasons articulated in the statute on the Transportation Code 545.058 are present. So that alone, him going into the shoulder without a permissible reason, is enough to perform the traffic stop. And that, taking that into account with Hardin, which he he failed to maintain a single lane with other vehicles around, provided enough of a community danger to allow the officer to perform that initial stop.
Where's the danger?
It would be the other vehicles present, Your Honor.
He doesn't articulate that, though.
He does articulate that there are other vehicles.
All he says is there are other vehicles.
That is all the case law requires. He doesn't have to say there's a vehicle right in front and right next to him. The case law requires that there be other vehicles within the vicinity for it to be.
Right. In the case law.
You don't know if it's in the vicinity, though. All he says is that there are other vehicles. That's so vague. You say other vehicles in the vicinity. He doesn't say that they're in the vicinity. He just says there are other vehicles, and that's so vague and conclusory.
Your Honor, the case law does specify there only needs to be a minimal level of justification for the stop. In this case, that is enough, where there's other vehicles around to provide that additional threshold for failing to make a single lane. In addition to no permissible reason to enter the shoulder, there's nothing there to indicate
Right.
there is a permissible reason.
If we're taking outside of the failure to maintain a single lane, and we can go into the other part of the transportation code that this defendant violated, which is veering onto the shoulder, he did not do so for one of the 7 permissible reasons, and thus the officer has reasonable suspicion to stop him.
You're veering. That is 545.060, right? Isn't that part of your,
And I'm just going to say it. I'm the best driver.
that's the weaving, right?
It's a different one.
Because you just said there's another violation of the transportation code.
Yeah, and it's under 545.058 is for entering the shoulder.
Right.
May I address the court, please, Your Honor?
Hold on, let me pull that code up. So that's
545.058.
The transportation code.
All right, let's see. That is driving on an improved shoulder. An operator may drive on an improved shoulder to the right of the main traveled portion of a roadway if that operation is necessary and may be done safely, but only if to stop, stand, or park, to accelerate before entering a main travel lane of traffic, to decelerate before making a right turn, to avoid a collision as permitted by an official traffic device. Okay.
Yes, Your Honor. So in terms of their argument.
Wait a second. People are very, very, very nice here. I'm nice.
About the driving on the shoulder under Lothrop, their case that they're citing, the case itself says, and I quote, merely driving on an improved shoulder is not prima facie evidence of an offense. That's their case. That says the exact, that doesn't benefit them at all. In terms of Hardin, their own case, based on our review of the record and precedent, we conclude that the detaining officer did not have reasonable suspicion to stop Applee for violating Transportation Code Section 545.060. Again, that's their case. And in that one, that's where the vehicle's tires crossed over the fog line, just as in our case, into the shoulder. And in their own case, it says that was not reasonable suspicion. And so, you know, I would like to, you know, highlight these 2 cases because I think they're directly on point. I don't know why the state did. In terms of State v. Hernandez, which is 2016 out of the 4th Court of Appeals, and I have the appellate case number, but I don't have the specific site.
My only concern is there an element of unsafetyness? That's all I want to know.
To just address one point briefly, in the case Lothrop, they do say that really driving on an improved shoulder is not prima facie case evidence of an offense. However, if it states explicitly that the offense of illegally driving on an improved shoulder can be proven in one of 2 ways, either driving on an improved shoulder was not necessary part of achieving one of the 7 approved purposes which are articulated in the statute, or that it could not have been done safely. And here, we're again going back to the 7 articulated purposes.
The shoulder of the road is the part of the road to the right. So you drive in the 2 lanes, but there's that part to the right you can pull off on. Like if your tire goes flat and you need to pull off the road, the highways have the shoulder. That's what we call that little space right there, the shoulder. And you're not supposed to drive along the shoulder. It's really a bad idea to drive along the shoulder because there's all kinds of trash and stuff on there. You're just gonna kill your car and your tires. But he was driving on the road and he crossed the line and then jerked back onto the road again. That's why he got pulled over.
In the statute that are not present here. He entered halfway into the shoulder and then jerked back into the lane. After previously having just gone through a green light. So there's no indication that he's allowing a vehicle to pass or anything like that. He went through a green light, entered the shoulder, and then jerked back.
So by your theory, then, any single person that ever drives a mere nanosecond to the right of an improved shoulder is now violating this offense, this transportation code.
He wasn't just
law can't be like that.
It wasn't just announced. He went halfway in. So he veered halfway into the shoulder. It wasn't just like a little deviation. He said, the officer said half.
Anthony, thank you so much. I really appreciate it. But remember, you've had a lot to drink tonight. So maybe you want to put your credit card away. Maybe you want to put your credit card back in your wallet tonight. But I so appreciate it. And I'm so glad you're able to come in here and talk with everybody. Thank you so much.
Halfway into the shoulder and then jerked back into the lane. So he went out and then came back into the
So are
lane.
we supposing that that's like half a second of driving on an improved shoulder? Is it 1 second? Is it a minute? Is it?
I'm sure it should matter. I mean.
Because the legislature articulated 7 specific reasons why that would be permissible, and they wouldn't have.
If an old grandmother who is 70 years old is driving on a freeway and accidentally
And but that would provide the minimal justification just to perform an investigative, a stop, just to investigate. It wouldn't be an arrest or anything like that. It would just be the traffic stop would be allowed at that point.
I don't know. I don't think that the officer wrote enough in the report. I don't think that the unsafetiness as far as, saying that there are other cars around. I just don't think that there's enough.
Yes,
All right.
Judge.
I'll find no probable cause.
Thank you.
Okay, ready? Come on.
All right, guys. We made it to the end. Thank you so much for coming out today. I appreciate it so much. Anthony, go into Discord and talk. Don't do what you want to do. Do what you should do. Okay? I hope you guys have a great day, great Sunday, and I shall see you all tomorrow. Behave, guys, okay? Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes hear a sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh.